So as Aggie mentioned, I'll be talking about regulations that specifically apply to children who are caught at the border. So again, I'd like to say that this isn't a comprehensive list of everything. This is just some of the more important things that we've encountered. So one of the things to look for are written admissions. So ICE cannot use a written admission by an unaccompanied minor under 16 years old. However, the BIA has allowed this anyway. Another really important thing to look at when you're dealing with children is the I-770 form. And what's important about this is that this is something that the government must give the children. And just because they've provided another form that isn't the I-770 form, it does not cure the violation according to a New York City IJ, but then the BIA in an unpublished decision said the opposite. They said that, even if the child did not receive the I-770 but received sufficient warnings, it doesn't matter. Other things to check for are whether CBP gave the I-770 but the kids did not understand it, or if CBP gave it in the wrong language, and that's usually something that will allow for your client to win, or if CBP forces the children to sign it without having a chance to read it. So it's also a good chance to win, but it's very difficult to prove. Another thing is if CBP refuses to give them a copy or after signing it. And it's important to analyze whether CBP wrote that they gave it to the child, but in fact they never did. Okay. Also, if CBP gave the I-770 only to the conservator, that's something that you might want to look into and litigate. And although the regulations say that CBP can serve the NTA and the arrest warrant like that if the kid is under 14, the regulation does not cover the I-770 forms. And although the regulation says that there's no need to serve an incompetent person in an institution, you want to check whether or not your client, whether the child was actually competent at that time. And you would also want to argue that due process trumps the regulations that are in place. A warning is that there are some New York City IJs that might refuse to terminate for I-770 reasons because they misinterpreted the unpublished BIA decision, and they might state that even if the child received no other warning, the fact that they did not receive the I-770 form is irrelevant. So this is a sample copy of what the I-770 form looks like. If you look at the bottom, you'll see it states Form I-770. So that's something something you would want to look for when you're dealing with a child. Rex, would you mind maybe going over some of the quotes that are on this form? It's in Spanish, so.
Well, just some of the, could you go to the next slide, please?
Sure.
Some of the things it says, he leído este aviso, so there's a check mark next to it, so the question is whether they have read the advisals to the child, or whether, whether the child has read it, or whether the advisals have been read to the child. So the officers will fill it out and then get the child to sign it. So those are things to read over. And this, of course, is the Spanish version. There's also an I-770 version that's in English. So just try to look up what the child might have brought to the meeting with you of what the child got while the child was in the shelter.
Thank you. Okay. So now about the NTA service. The NTA must be given to the parents of the child if the child is under 14, and it must also be given to a person where the child resides and not only to the child. However, there's no remedy where there was no prejudice. For example, if the child was independently informed, and if the child independently informed her parents, and if they've hired a lawyer. So in that situation, they were not prejudiced by not for their parents having not received a copy of the NTA. You can also see, like, you should also check whether or not the child is from El Salvador, and if they are, then you can look then ICE must honor the injunction in a case called Orantes. So in it, ICE must give advice to the child, both in writing and verbally, and they must also inform them of their right to apply for asylum, to be represented by counsel, and to request a removal hearing, and DHS cannot coerce them to drop any potential asylum claims. They must also make legal materials available to them in Spanish, and the libraries in the detention centers must be accessible to them. We're not aware of people who are seeking to litigate this, who are not litigating this to seek termination, but it's definitely something that, you know, we should try. Also, there is a hold rooms memo available, and it's something that Catholic Charities and the National Immigration Forum has been working on together, and Rex has the best available copy, so if you're interested, you can always reach out. So there are a lot of regulations and policies out there, and you should always talk to other attorneys and try to make document requests about the policies that affect your case. So some of them include the fact that arrests must be lawful if they are done without a warrant. Also, the child cannot be arrested and examined by the same officer. Also, ICE cannot use coerced statements, and there are a few more listed on the handout, so you can look at that. And of course, like, I really want to reiterate the fact that this is not a comprehensive list, so if you're dealing with a child, you want to do your best to try to represent this individual, and, you know, definitely talk to other attorneys, do the research, find the policies that best fit your case, and, you know, make the document requests to try to, like, you know, win the case for this child.